afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speakers. If you have a question, we encourage you to put those in the comment section below so that we can be sure to address them. Episodes are released each week following the live broadcast, so hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Peter Levine out of Los Angeles, California, and David Rash and Jeff Mueller out of Weston, Florida with us to talk about trial losses and lessons learned. Sometimes, despite our best efforts, trial does not go as planned, and we get an outcome that is less desirable or outright terrible. As Papa Don says, edge is not a quick fix, and it is not a magic wand. Sometimes we do not use it correctly, or we think we understand a concept and how to use it, but we get it wrong. But when we don't get what we want from trial, it's an opportunity to learn and grow, not to blame the jury, not to blame the judge. Peter is going to share with us about a loss he had and what he learned from it. And David and Jeff are going to share about a case they had and didn't do very well in as well before becoming full-time students of the Edge philosophy. Peter, David, and Jeff, I'm going to turn it over to you to remind us that we're all human. We do not always get the most perfect trial results. And please share with us what you learned from the not-so-great trial outcomes.
Good afternoon. Hey, Peter, Jeff.
Good afternoon.
Well, I'm David Rash, and I'm happy to be with Jenna and have this discussion because it is so important. And why is it so important? Jenna talked a little bit about that, but you go to the seminars and you attend organizational meetings, and you always hear the great war stories about the cases we win, what we did win, but you very rarely have attorneys who get up in front of a crowd of people and tell them about the case they lost and why they lost it. But we all know you learn much more from your failures than your successes, and it's so important, particularly once you learn the edge, the cutting edge, and the importance of the system and root cause analysis. It's so important that when you do lose a case, that you undertake that same perspective on yourself and the case so that you can figure out what happened and why it happened and prevent it from happening again. So Jeff and I practiced together and have been practicing together for, 6 or 7 years. And the case we wanted to talk about was a case that I think I had initially had the case before Jeff even joined the firm. And it was 2013 or 2012. And so I didn't start my first reptile seminar, and it was a reptile at that time was in 2014. So I had been working the case for a couple years and doing discovery and all the things that we used to do the old ways before I even started my first Welcome to the Revolution seminar back in 2014. And even then, as it has evolved and become the cutting edge, learning and understanding how to use it, why you use it, and what it means takes time and hard work. And so this case, unfortunately, didn't benefit from the real system and the real things that you learn through going to the college and to the seminars and learning Mr. Keenan's system. And unfortunately, we had a 2-week trial end in a total defense verdict in a very significant medical malpractice case here in Florida. It was a case that was in litigation for 6 years. had been set and reset for trial 3 different times. One time a hurricane came literally a couple days before we were supposed to start trial and decimated a lot of Florida. Another time the judge had a surgery, and then a defense counsel had a trial. So by the time we got to trial, it had been 6 years. A lot of things change over that period of time. But the main thing is, after the loss, it was a huge gut punch. I mean, it really, really hurts. The people that we represented were amazing people. And ultimately, the husband who the case was about, he's since died since the trial. And I still keep in touch with the wife on Facebook and other ways. And, you know, we have developed a friendship. And they understood that it wasn't the result, but it was the journey and the battle that we went through. Because there aren't a lot of people really that have the stones to try medical malpractice cases and actually go do it. So they understood. And that was helpful in my recovery, so to speak, from the loss. But we did an introspective, and I had to start with myself first. I had to look at myself and what it was that I did, because it's never the jury, it's never the judge, it's never defense counsel. It's always yourself, because those are things that you can control in some sense. But what happened in the case was I was very emotional. It was a big case. There were 4 defendants on the other side, so there were 4 defense firms. A lot of piling on. They were very difficult to deal with, and so I developed a very bad relationship with them that was very clear during the trial, that I did not like them, and my anger towards them showed. And I think that was a big reason why the jury just did not trust me or didn't like me. So my first introspective thoughts were that, you know, I didn't control myself during trial like I should have. Jeff and I had actually the year before tried a medical malpractice case. And it was a newer case than this one. So we had been even though it got to trial before, it was a newer case than this medical malpractice case we lost. And it was a case that we were able to better implement the tools and the system that we had learned from Mr. Keenan. So it was interesting, because the year before we tried that case, it was a newer case, a smaller case with one defendant, a medical malpractice case in a very, very tough venue in Naples, Florida, where they rarely have any plaintiff's verdicts, particularly in the medical malpractice cases. It's where our former governor and now U.S. Senator Rick Scott is from, that area. So it's a very bad venue, if you can say that, for plaintiffs. And we won the case. And so coming off of that win into this case in a different venue in Florida, I had an idea what I wanted to do and how to do it, but for some reason, I just didn't. And I let my emotions get the best of me. I was not calm and really reasonable during trial, and that was a big problem. Something that you always have to do is hold your emotions and make sure the jury sees you as being cordial and friendly with the other side, and in the presence of the jury. So I started with that introspective. I couldn't blame myself for the lack of hard work or effort put into the case, because I had put a tremendous amount of work and effort into it, and only could pinpoint that behavior of mine during trial was a real problem. And have since, in comparing it to that case that we won before, the year before, it was night and day. That case was very calm, cool, and collected during the whole trial. It was a single defendant. There weren't 4 law firms involved, and they were much nicer people to deal with. So, and I think that was just one of the major factors in losing the case. And I'm sure Jeff would say the same thing, because he sat, kind of next to me the whole trial, and I'm sure that he saw those antics that were just really uncalled for, and had a major problem. So
I'll add on to that, is because what that does, in my opinion, is that draws the focus away from the case, and it draws the focus onto the lawyers. And you could tell that the jury was much more focused on our witnesses and our case we won, and they were definitely focused on us and our table during the trial, and the antics going on between the lawyers in the case that we lost. And to have the focus off of us as lawyers is much more important. And so we try our hardest to stay cool, calm, and collected, and be the positive light in the room when we go to other trials. And it helps.
I imagine it probably plays into the preconceptions people have about lawyers too, that we're kind of all about ourselves, and we're just arguing and bickering about things that aren't really important to the average person, or that they don't even really understand, that kind of thing. Did you get that sense as well?
100%.
And I think a lot of it not only came from just anger and dealing with the black hats on the other side, but it was fear inside of me of losing the case, not trying it appropriately, and just all around insecurities about myself. So from that, outgrew this behavior, making faces and scowling when questions were asked and answers were given. It's just something you cannot do. And I think, as Jeff said very astutely, that it takes the focus off of your case and puts it on you where you don't want it. But let me just share you. So we tried this case. It's a medical malpractice case. There were 4 defendants on the other side. Involved a 75-year-old man who was a very, very heavy smoker for 30 plus years, a heavy drinker and alcoholic, and had worked for 30 years as a telephone line man, with asbestos exposure on the job. He had other heart, health problems, emphysema and COPD. And what happened was he was having routine blood work, and it showed his sodium was real low in his blood. So they sent him to the emergency room, and in working him up at the emergency room, they did a CT scan of his chest, and there was a big mass in one of his lungs. And of course, with the low sodium and this big mass, they immediately think it's cancer. And so they start working him up for lung cancer. And they do a fine needle aspirate biopsy of this mass in his lung. And the pathology report comes back and basically says that it's suspicious for cancer, but it doesn't say that it is cancer. And based upon that pathology report, the thoracic surgeon says, we need to take out your lung. And so he agrees, and this is all within a matter of a few weeks. They take him to surgery, remove his lung, and it's not cancer. So the case, from the initial impression, you would say, okay, there's a lot of negative attribution, but sounds like there's a good case on liability. He was left having to use an oxygen tank, and he couldn't play golf anymore, and the things that he had was doing when he retired in a retirement community in Florida. And so, we took the case on, and I think the initial mistake was not properly applying the case selection criteria, which is so important. And there's a reason why it is the shortest chapter in the original book, but it's so important because it sets up the entire framework for your case and helps you with the all important codes that you need to embed in your case as you go forward. So that was the initial problem, not knowing and not having experience in doing that, because we are just beginning to learn the reptile at that time and the initial framework for the cutting edge. And I go back and I look at that and I think maybe this is probably a good chance, if we had done that appropriately, maybe focus grouped it at that time, that we probably would have turned the case down. But moving forward from that point, it really, looking back at the depositions and the discovery that was done, it was the old style. I mean, particularly with depositions, what we've learned over the past few years in how to take depositions properly and not a discovery deposition makes all the difference in the world. And, Jeff he was looking at the depositions, and he would buzz me on the phone in my office and say, you were asking questions like this and doing this, and he'll tell you what they were like.
I went through and looked at a couple of them just to see, to go look at them. And that was the defendant physician depositions. And they all start out with, the rules of the deposition, if you don't understand my question, and then where do you go to school? Where do you live? What's your address, your phone number? And you can tell the witness is in a groove. Everything's going to plan, just like their defense attorney told them it was going to go in the same order they were told it was going to go. And that's how all the depositions really of the defense witnesses and a lot of the witnesses in the case were. And, we've learned, through Keenan and everything and Luther and Mindy and everybody that's involved in the system, that is not how you do it. And, we have not done a deposition like that since this case was a loss. And I think it shows the depositions are much more useful when you're going to prepare for trial and getting your hits and what you want to score points with the witness at trial. And to try and find things in these depositions that we could really, squeeze these witnesses on at trial was difficult. And so it's just a night and day difference on the power you have going into these trials with doing the depositions the right way. And that's a huge learning point from this.
Yeah. I mean, and there was no emotion, right? In the case, the only emotion was me. And the case lacked the emotion. The emotional stool was not found really anywhere in the case, and it clearly became a case about the medicine. And, obviously that's where you don't want to be at all, particularly in a case like this where you have, in Florida, you've got three separate defendants in the case, a pulmonologist, a pathologist, and another pathologist. They all have their own lawyers. They all get their own sets of experts. So I have a set of experts. Then there's three sets on the other side. So, there's three opportunities for them to cross-examine my witnesses. They get three direct testimonies of their pathology expert. I have one pathology expert. So it's kind of a very difficult case to try when you have multiple defendants like that here in Florida. But you make it about the medicine, you're going to lose, because there's so many experts on their side. They just have to stand up and say, there's three guys here, Stanford, Yale, and, Sloan Kettering or whatever, top people across the country saying that there was no, breach of the standard of care. How in the world can you get beyond that? And if you're talking about the medicine and the cases about the medicine, you're going to lose that every day. So that's the dynamics of that. And, if you don't have your discovery, particularly, obviously your depositions done appropriately in the manner in which Mr. Keenan and the Cutting Edge teaches you, then it's a recipe for disaster, because it will become about the medicine and you can't avoid it unless you take control of it with that method of taking depositions. It was also a case lacking the system failure that we have to have in every case. There were three individual physicians on the other side. There was no hospital in the case. And that was a failure on our part strategically. But there's, the hospital where this all occurred is a hospital in Florida that has sovereign immunity. So there's a cap of $200,000 on any damages you could get against them. So there were some strategic decisions made early on, and I think there was a legal a motion filed by the defense that the hospital was going to get dismissed anyways. So it ends up just against the physicians. But the lack of understanding and experience with the Cutting Edge really hurt us, because we didn't understand how to make it not about the medicine. And on top of that, we were not 100% correct on the medicine. So with that domino effect, it really became a problem, and the weeds grew like crazy, and we didn't know how to get out of the medicine, because we didn't have the tools that we needed and that you get when you go to the college and attend the seminars and refer cases and get to the beach and the workshops. So that was an interesting dynamic in that part of the case. But we also got schooled. I think Jeff was talking earlier too about the visuals during the case, right? We had a lot of exhibits, but tell them what they were, Jeff.
Yeah, we had a lot of, we'd like to use blow up boards that we feel comfortable using those. You can write on them if you need to. I'm sure everybody's used those before, but the one thing I look back on and just trying to reflect on this in advance of today's podcast and also just thinking back on the trial is that I was thinking back and I realized we don't have any mechanism of injury, and we don't have any event diagrams whatsoever. All we had were blow-ups of medical records, which played straight into the hand of the defense of this being all about the medicine. And, we thought at the time, of course, or we wouldn't have presented them, that those were persuasive for our case. But, we had to explain every time we put them up what they were. And there was no visual boards or timelines that we had that we could just put up and let the jury digest without having to say anything. And, if you spend the time that it takes with Mr. Keenan's system, you will learn just how critical and just critical those are to your case, and to let the jury come to their own conclusions about who's right. And if we would have had those and we wouldn't have been able to focus group those first, I think we would have been in a much better place going into trial. And we would not have been fully so deep in the medicine, and which was a big problem. And there were other challenges in the case that piled on. We had it was a far away for us, long trip every time we had a hearing, and the defense was beating us down on that. on increasing the costs every day in the case, and that adds to the emotion that we have on our side as lawyers. But just thinking back on the visuals, that was definitely a fault of ours. And I also think back to what David was talking about, the emotion and working the damages aspect up in the case with our before and after witnesses. They were all, pretty much family members, except for one that we called. And, as Mr. Keenan will teach, that's important, but those witnesses are biased in some regard. They are too close to the case, and you need witnesses who are friends that can come and tell the story, who don't have a dog in the fight. And I don't think we had really worked that side of the case up enough where we needed to. That was another failure of ours. So
this is a case that you guys did as you were learning the edge, being introduced to the edge. And so will you share with us how you were introduced to the edge? I mean, how did it come that it was right there? And then I want to incorporate Peter a little bit about how even when you have done quite a bit of edge, sometimes we just don't use it right. Yeah, so go ahead and David and Jeff, tell us kind of how you got into it, who told you about it, how did you try to incorporate it?
Very interesting. I was part of a bigger plaintiffs firm in Miami. We did a lot of medical malpractice. We did mass torts. So we had about 15 lawyers and a total of maybe 50 people, staff members. And so in 2013, the firm imploded. I left. It eventually dissolved, but I left and started my own firm again. And so I had a couple cases that came with me. This was one of them. And it was in its basic very beginnings at that point in time. And when I went out on my own with my firm again, I was just looking for something different. And I don't remember how I came about learning about the reptile at that point. But in 2014, I attended the Welcome to the Revolution seminar. I think it was out in Denver. Didn't know anybody, didn't have any idea what it was about. And I went, and both Mr. Keenan and David Ball spoke at that seminar, and I was, I didn't understand it very well. I mean, I wasn't born in the South, but I've been in the South all my life, so I'm a little slow. And I didn't really comprehend it. But I was very, very intrigued. And from that point on, I started going as much as I could, whenever I could, to seminars, to the colleges, and, became a master's graduate. And it has been for, practice changing, of course. And I've had, cases referred with Mr. Keenan. We had a giant case that was enormously successful that got resolved in 2019. And I've got two other cases, a trucking case and a med mal case with Greg Luther and Mindy. So I'm all in on the edge, cutting edge. And I was there to see the transition from the reptile, and it's just been, it's night and day. And I've been to the beach workshops many times, and you just cannot say enough about what you learn. Even if you weren't a lawyer and you never put this stuff to work in your case, it's just an incredible learning experience. And so, but and then Jeff joined my firm during this case, right? This case that we were talking about. Jeff was actually working for an appellate lawyer who I had hired to work with me on this case. And he was an associate of that firm. And So most of the time, Jeff and I, when we would have a hearing in the case, we would drive. It was a 5-hour drive from where we are to Central Florida, in Ocala, Florida, where all the horses and beautiful horse ranches are. And it was funny because we came back from a hearing and Jeff said, I was telling him how I was looking for an associate. I needed somebody, because I was by myself at that time. And we had gone all the way up, had a hearing. I think we spent the night in the hotel up there because the hearing was the next morning, and then came back. And that whole time, he never said anything, but we pulled back in the office when we got back. And before we got out of the car, he said, would you accept me applying for that associate's position? And I said, well, let me talk to your boss, because I didn't want to, steal her associate. And they gave their blessing. And then Jeff and I have been working together, and he's now in the name of the firm for the past 7 years. And we've tried 3 cases.
Yeah, I think that's right.
3 cases, 1, 2, and lost this one. But, you go through a 2-week trial. We rented a house up in Ocala. Our appellate lawyer was there. And that's another thing I wanted to bring up that was important. Appellate lawyers are very important, but they're not trial lawyers. And I think, and it's not their fault. It's my fault for questioning myself, during trial about certain tactics and things I wanted to do, but would get talked down from doing it by the appellate lawyer. And some of it, which were edge related things. So you just have to be super careful in that regard and trust your instincts and what you've learned, as opposed to what the appellate lawyer may tell you. Obviously, their counsel is important, but go with what you've learned from the cutting edge and Mr. Keenan 100% of the time. The last thing I want to say is, we'd actually focus group this case 5 times before trial, but we really didn't know what we were doing during the focus groups. All of them were mainly like narratives, and we didn't have the case management criteria form. We didn't have the checklist that we needed to get things done before we really get going in the case. And so those are real important. Those are things that, depending upon the level of your participation and learning in the cutting edge, that you will come to know and be able to utilize, and really makes a difference. So I just want to, you sit there in trial for 2 weeks. You're afraid. You have moments of high emotion where you think you've done great things during trial, low emotion when the points are getting scored against you. And then your heart's beating like a drum when the jury's out. They went out on a Friday in this case. I think about noon on Friday. And at the end of the day, they didn't have a verdict. So the judge sent them home over the weekend. They came back on Monday, and then, deliberated a few hours on Monday and came back, and, the verdict's read. And I want to share the verdict form with you because I look at it from time to time can you see that?
Oh, that breaks my heart.
And so, in Florida, the first 3 questions were about the negligence of the 3 defendants. And of course, there's no. And then that's it. And it's just heartbreaking when you're sitting there and then, the packing up of the stuff from the courtroom, gathering your stuff at the hotel or the house where you're staying, and then driving back 5 hours to South Florida in a case you've invested yourself in I mean, we would go to these people's houses every time we'd go up to Ocala, and they would feed us, or they were just super nice people. So it was really, depressed me for a while after this case. So don't be afraid, but fear's good. Get in the courtroom and try these cases, because if you're not trying them, you're not going to win them, and you're going to lose them sometimes. But don't blame the jury. Don't blame the judge or the black hats. Look at yourself and make sure you autopsy it and figure out where your flaws are.
Thank you so much, David and Jeff. And I want you to continue to kind of join us here as you have things to say. One thing I do want to point out that David said is, when you do focus groups, don't just do focus groups. Do them the right way. I have a lot of colleagues who say, I don't do focus groups because those people are not going to be on my jury. And if you're not presenting the information correctly to that group of people, then that is correct. They're not going to be on your jury, and they're not going to give you usable feedback. But there are so many resources with the Edge, either Edge attorneys who do focus groups in your state, or now that we're on Zoom, really, they could be anywhere. You can sit in on the ones that Dawn does with KLF. You can, I'd encourage you to have somebody else do them for you who knows how, so that you can kind of watch and see what you need to be doing to really get information. Because sometimes we put our version of the case in front of a focus group, and they love it as much as we do. And we're like, oh, yeah, that's great. But your version of the case isn't going to be the only thing they hear at trial. So that's a really important point for everybody to know about focus groups. We talk about it all the time, and you got to be doing them, but do them right. So, all right.
And if you're not comfortable doing them, get somebody to do it from the cutting edge to do them for you or with you, because they are critical. And if not done right, then you're just wasting your time.
Absolutely. Absolutely. All right, Peter, tell us, you've been with the Edge for some time now. Share with us what happens when we know the things but don't do the things.
Well, first, thanks for having me here. And I appreciated hearing about David and Jeff's. And I was taking notes because many things they said hit the mark. If I could show you my desk, you would see all my notes of what happened in this case. Basically, I am a graduate, master on faculty, but I'm still a grasshopper, as they say, still learning. This was a case where the hospital was a primary stroke center, and they did not have qualified people who had no idea about even the code stroke policy. My client was having a stroke, and he happens to be an interventional radiologist. So when he got in the emergency room, he told them where to look for the blood clot, okay? And the neurologist, got very defensive and said, are you trying to diagnose yourself? And he demanded TPA, and they let him languish for 7 hours while the stroke was doing its deed. But here's the problem. The problem was that he had a phenomenal recovery, okay? And we couldn't get over that. I had a partner on the case who's also an Edge, doctor, lawyer, phenomenal. But here's the bottom line, okay? If you don't have before and after witnesses, and if you don't do your client biography, and I never understood how important the biography is, and I never understood the power of before and after witnesses. Our client would not let us come to his house. We hired someone to spend the weekend or days with him to follow him around. He wouldn't let us do that. And I learned a long time ago as a young lawyer, my boss taught me something very important lesson, and that is you can always beat the other side, but you can't beat your client. Okay? I mean, I feel, first of all, I had a great time trying. It was a 4-week trial up in Ventura. There were 4 defendants, the hospital, 2 radiologists, and a neurologist. And I learned something very important. My partner kept telling me that the defense will get experts to say anything. If the moon was made of crap, they will say that. I mean, may I share something here? Okay. This was right here, that white dot was a blood clot. Okay. And they got their experts to say that, and this was a very qualified expert, that 7 billion people in the world could see that white dot. But the fact that the radiologists missed it did not violate the standard of care. Okay. Everyone on the focus group saw it. But I think the problem was that we couldn't prove damages. That was the basic problem, okay? My client made more money afterwards. He was making $350,000 a year, over $30,000 a month. And I think that was a big problem. Mm-hmm. And we begged him. He would tell us, for example, that he had post-stroke fatigue. And as a result of this post-stroke fatigue, he was going to have to retire in July. Yet, he continued doing his work. He continued making the same money. And no one believed him. And he would tell us, that his partners all knew he was going to retire and wasn't doing the job. And we'd speak to his partners and they couldn't back it up. Okay. Now I'm going to tell you my system failure. And then he tells us that his best friend, who happened to be a doctor, would also back it up. And then when I called and spoke with her, she said, don't take the case to trial. He really isn't that injured. Okay. And I think, and he said, so why did we go to trial? You would ask, right?
Why did you go to trial, Peter?
Why do you ask that? First, there was a no offer case, right? Mm-hmm. And I think the other problem was the client was paying all the expenses. Okay. And we did about 22 focus groups on this case. And, we had a great time. I must say this. I want to tell everybody this. Losing hurts. It hurts. And the client stuck me with a lot of money at the end and refuses to pay. And, I'm getting sued by people over it. And we're talking over 6 figures. So I learned a lot of lessons here. I learned that I put my client on a pedestal when he really turned out to be a jerk. Okay. And I think David is right. We couldn't get out of the medicine. We couldn't get the emotion in the courtroom. They had 4 defense lawyers, and we didn't have, and with all respect to David and Jeff, I got along with the defense lawyers. I became a friend with one of them. But it's like the courtroom we tried the case in front of. I mean, I got notes of everything that went wrong, but I do want to say, first day of trial, the case was pending for about 4.5 years because of COVID. But here was another mistake. We hired a phenomenal life care planner. Phenomenal. But because of COVID, there was a 2-year delay, and we didn't update the care plan. Okay, so update your care plans. because things she said he would need 2 years from the date she did it was still in the plan. And here we are in court at that 2 years after she did it mark, and he wasn't needing that stuff. So I guess our credibility was going downhill here. And I take responsibility for these things. I mean, there are no victims here, in my opinion. Okay. It's not, the Edge is a phenomenal system. If I had trusted my judgment more, I might have been more harder on my client. So instead of using we tried an issue of earning capacity. And, I can still picture the courtroom. I mean, we had a great time. I loved trying this case. I was on a high, even after I lost, and it hurts. I mean, I'm looking at David's verdict form. That's what mine's like. Imagine sitting in court, thinking, and right, first question, no negligence. Man, it hurts. And David's right. You got to pack up. And these defense lawyers were good, and they were dirty. They're dirty players. Let me tell you, okay. From the day the trial started, the first thing the judge says is, I know Don Keenan. I've never told anybody this story, okay? And he started telling us how he doesn't like Papa Don. Okay. Now, this was in the courtroom down the hall, I guess, from where Papa Don tried that case in Ventura, where the guy was tied down and they beat him up or whatever. This judge was a defense judge, and he talked about how he didn't like Papa Don. He had personal reasons, and he granted all the reptile motions. And I will say that we had Plan B. I mean, he wouldn't let us talk about safety rules. He wouldn't let us show anything. And doing focus groups is fantastic because voir dire was fun. I had a good time. I really enjoyed it. Imagine, I do a question where you want to ask, would you fly on an airplane where the pilot's fatigued? And one of the people in the jury is a 747 pilot. So, and then I had, he didn't make it to the jury, of course. And then someone else in the panel, he did root cause analysis for a living. I mean, it was great, but it's not enough. You see, that's the lesson. You can't, when you put lipstick on a pig, it's still a pig. Okay. And the defense lawyers were so dirty. They would say to our life care planner, doctor, I'm having a what the F moment here. You're saying that he needs a caretaker. Why doesn't he just get married? And I'm thinking, how could he get away with these remarks? But you know what? Even when the defense is a jerk, they can still win. You see? There were so many lessons here. I mean, they would lie, and they said to the life care planner that 2 nights, my client is left-hand dominant, and the stroke affected his left side. And allegedly he couldn't use his left hand for fine manipulation on interventional radiology procedures. And then he would say he got fatigued looking at films. So the lawyer just out of the blue says, because one night my client came to my room and we were talking, and the lawyer says, Dr. Kwai, I was at the hotel the other day and I saw Mr. Levine's client take his luggage and toss it over his left side and carry it. I'm thinking to myself, what the fuck, excuse my expression, but so I made a motion in limine and I learned a very important lesson here. These guys will ask questions without ever having the facts to back up their questions. Okay. So I'm never going to let that happen again. All right. I learned that from this trial. And I mean, they would make motions in limine like the precluding us from referring to the nurse as a traveling nurse. The nurse that that worked in the emergency room was a traveling nurse. He was not a member of the regular staff. He would be hired through an agency. And he testified in deposition that he had no idea that there was a code stroke policy, which says when someone shows the signs and symptoms of a stroke, you must call a code stroke, which is like, you know, bells and whistles, everybody's supposed to come around. And the hospital said, no, we don't have to call a code stroke once you're in the emergency room. And he said he was never trained on the policy, but the jury still, you know, didn't find there was negligence because we couldn't prove damages. That's my estimation of what happened here in this case. So they make a motion in limine to keep out the fact that he's a traveling nurse, okay? And the judge grants it. It's irrelevant that he's a traveling nurse. Nurses are nurses. It's prejudicial to mention it in opening statement or whatever, okay? He grants it. After I give my opening, the other side stands up and refers to him as a traveling nurse, okay? I went through a lot of self-reflection about when do you object, when do you not object? And we let a lot of their crap go because we didn't want to be on code. So it creates a conflict in my mind, you know? How do you stop that stuff? And the judge, of course, wouldn't let us discuss deterrence, wouldn't let us talk about the community, even though it was a community hospital. But I don't blame the judge because as a good edge lawyer, you have to be a woodpecker and, you know, preparation is everything. But we couldn't get the emotion going in the courtroom, okay? That was the big thing. We couldn't get before and after witnesses. So that's a big takeaway for us, getting those before and after witnesses. So what do you do when your client, I mean, we were stuck, I guess, you know?
It's tough. It's tough. And, you know, everybody listening, it sounds elementary to say so, but make sure that you go through the very basic elements of your claim. And I mean, because we heard from both David and Jeff that they had so-so liability. And Peter is sharing that you didn't really have the damages. And so, you know, you may love your client. It doesn't sound like Peter did, but he's at least paying the bills, so that's good. Or you may love the case, you know, you might love the medicine. But if you don't have the elements of your claim, it doesn't matter what trial philosophy you subscribe to, it's just not going to hit. So like I said, I don't want to offend anybody by saying, make sure you know what cases you're bringing, but I forget all the time. Youngie and I just took a case. We took it like a year and a half ago, maybe. And we found out just recently, we do not have causation. And okay, now we're like, what do we do? Right? Okay, well, thank goodness, you know, trial's a couple months away and maybe we can get them to the table with some kind of resolution. Hopefully they haven't figured it out yet. They've switched to lawyers like 3 times. So hopefully they're too busy, but little things like that, you know, in the hubbub and the bustle of running a law firm, because we are business people as well as lawyers, doing all of the things that need to get done. Sometimes those things kind of slide by. So, you know, those are certainly things to consider when
and juries are smart, you know, they get it.
Yeah.
Another thing that I felt I wasn't handling correctly was the jury was sitting behind us the whole time. They were not in the jury box because of COVID. They had to be spread out. And that I think, you know, I got to learn how to handle that better because every time I would turn my chair, you know, to look at them, you know, you look like you're looking at them and you know, you just, it's very difficult.
Mm-hmm.
But
that connection with the jury is so important too. And I think I think you can do it virtually. I think you can do it. I know you can do it in person. But if you can't make eye contact for some reason, if you have to have your back to them, that's really a challenge. So, and think about asking judges ahead of time about that with the setup with the courtroom. Where can we be? And explain why. If you have law in your jurisdiction about that, if you have any way you can argue it, I think it's important.
I agree, but the logistics were horrible. Again, I'm not blaming anyone. I'm just saying that, it's all about preparation. And I will say this, that it was very depressing afterwards. It took me, and it's taking me still a long time, because I still got to deal with this client. They nailed him for $220,000 in costs, and we got it reduced to $21,000. Okay,
that's good. Good job.
Do you think you ever get a thank you?
No.
Never expect a thank you.
No, it's hard. I mean, the clients are tough. I mean, that's one thing Papa Don has talked to us about as well. And, I know all of you have experienced this, but if you are not clicking with your client, it's very important that you consider having the conversation. Maybe I'm not the right lawyer for you. If your agendas are different, maybe they don't want to go to trial, but you're a trial lawyer. And so that's kind of where you need to be headed. Have that conversation with them early on, and don't find out about it at the last minute. I mean, I've been absolutely where you are, Peter, with a client where I got an awesome verdict. I actually got a great verdict, and he was pissed. He was pissed because he wanted more, and he did not even deserve what he got. I don't know how I got that verdict, but he didn't deserve it. And he was mad, So there's always going to be that dynamic. Another thing to consider, because you want to like your client, you want to enjoy putting that person's case in front of that jury.
I agree. And I just don't think the jury cared.
Yeah.
If they don't care, you're not going to make it.
Mm-hmm.
So I didn't stay around after the verdict came in. As I know Papa Don, the jury, what are they going to tell me?
Mm-hmm.
Sure, I was embarrassed. I was very embarrassed, because you're doing the trial and you think you're doing great, and then you lose.
Mm-hmm.
Not a good feeling.
But Peter, David, Jeff, are you going to try cases again?
Of course, I got it. Of course, I got one coming up in 2 weeks.
There you go. Me too. Oh, we might be in trial together in different states. How fun!
We have trials every month this year. With the COVID backlog, they're all getting set here in Florida, and there's a huge change in the rules of civil procedure before the Florida Supreme Court, where it's going to be tough for both sides moving forward, and you're going to have your case. It kind of plays into our hands as cutting edge lawyers, because a lot of the work we need to do is before you really file your case, and the changes are coming, so that's going to be required for plaintiffs. So we've got a schedule this year that's really untenable, but we're gonna do our best.
Yep.
During this case, I even asked the judge for a conference before closing, just to let him know what I intended to do.
Mm-hmm.
And he said he never heard of an attorney doing that before, but I won't let you do it. Okay. Couldn't mention deterrence, it's only about this case. So
that happens. And actually, everybody who's listening, feel free to jump back on is it last week or 2 weeks ago? We had Amy and David Wiley on, Amy Gibson, David Wiley, and they talked about, you get these bad judges, bad venues, bad rulings, and how you can anticipate that and kind of move through those obstacles. And like Peter said, he had a plan B. There's only so much we can do in the moment, but there is a lot we can do after the fact to really reflect and move forward from all of it. So thank you all so much for being here. I know David has to run, and we're at the 1 o'clock hour. So thank you, all of us who joined us this week live for our episode of Fridays with Keenan's Cutting Edge. We will put the speaker's contact info in the description below. So if you need to, you may reach out to them with questions. If you like today's video, please click that thumbs up button to feed the YouTube algorithm, and please subscribe. And whatever else you can do, click alerts, all of those things that YouTube gives you the option so you don't miss our episodes. Next week, we have Michael Panisser with us. Michael is going to share with us about Pat Maloney's closing argument in a case called Flores. I love getting inspiration from hearing examples of powerful closing arguments, especially from trial legends like Pat Maloney. So I look forward to learning from Michael next week along with all of you. Have a wonderful weekend, and I'll see you next time.
Thank you.